Thank you. Hopefully you can hear us this time. Our next case is State of Ohio versus Susan Hines. Whenever you're ready to start, we can get started. Would you like to reserve any time?
Yes.
How much?
4 minutes.
Sure.
May it please the court and opposing counsel, Police Harris, 0064911 on behalf of the defendant appellants. Again, I reserve 4 minutes of my time for rebuttal. Your Honors, this is a simple case stemming from a non-accident traffic offense. Specifically, in September of 2023, Ms. Susan Hines was ticketed for one count of failing to comply with the order or signal of a police officer when she allegedly disregarded the audible signal of a police officer during a traffic stop. At the time of the stop, Ms. Hines denied disregarding that signal. She explained that she had a hearing difficulty, and she further explained that she simply followed the vehicle in front of her when the light changed. Nevertheless, she was ticketed, and in March 2024, she appeared in court to enter a no contest. Before the court found her guilty, the state provided a recitation of facts or an explanation of circumstances. Specifically, the state declared on or about September 30th, 2023, in Hamilton County, Ohio, the defendant Susan Hines operated a motor vehicle. While doing so, she failed to comply with the order or direction of the police officer by going around a marked police cruiser when the road was closed and she had been signaled not to go in that direction. So the sole issue before this court is whether that recitation of facts is sufficient for finding guilt. We allege that it is not. Specifically, pursuant to Revised Code Section 2937.07, when a defendant enters a no contest plea, the court must rely on the explanation of circumstances, not the charging instrument, not anything else in the back of the file, not specifically put on record. It is specifically the explanation of circumstance that provides the basis for the finding of guilt.
Well, Ms. Harris, what else should the state have said to prove recklessness?
Recklessness. So she went around the stop or the marked cruiser and recklessly put the lives of the officer in danger. Essentially, the state had to prove that she acted with heedless indifference because that is the standard for reckless behavior. And the state didn't allege it at all. The state completely left that mens rea out. And without the mens rea, the explanation of circumstances was simply insufficient.
Well, she admitted that she had been signaled.
I'm sorry, she admitted?
Since she pled no contest, she admitted that she had been signaled not to go in that direction, correct?
Well, so in pleading no contest, you admit to the facts of the offense.
Right. So as part of those facts, did she admit that she had been signaled?
I would submit that she did not admit that she had been signaled. But I would also submit that the actual charging instrument, right, the ticket itself, is not what the court has to rely on. The court specifically when you enter a no contest plea, the way the statute works is the court cannot rely on the charging instrument. The court is bound to rely just on the statement of facts, just on the explanation of circumstance. And so when the prosecutor read the facts into the record, it had to allege recklessness. And this situation is almost identical to Seven Hills versus McKernan, where in that case, it was identical because the charging instrument was sufficient. But when McKernan pled no contest, the statement of facts was insufficient. So she was found guilty at trial. But then on appeal, the Court of Appeals, of course, vacated it because of the same error. Essentially, they said, pursuant to RC 293707, you have to allege reckless at the statement of facts, right?
So that's the word, the prosecution you're saying. What you want the law to be that comes out of this case is that the prosecution in a no contest plea has to allege the mens rea?
I would disagree. That's not what I want the law to be. I would submit that that's what the law is. RC.
They must specifically state
Yes.
the mens rea in their statement of facts for a no contest plea.
So 293707 says the explanation of circumstances, the finding of guilt must be found in the explanation of circumstances. And that is specific in the statute.
But why couldn't the judge, based on the explanation of circumstances that was read into the record here, determine based on circumstantial evidence that there was recklessness?
Well, then I would, because that would actually, I think, that would take it from relying on the mens rea, which was not put into the record, into a strict liability offense. Because he's not then relying on anything in the record. There was no mens rea in the record. Because the state didn't put heedless indifference on the record. The state completely left the mens rea out. So if you're saying why couldn't the judge then just rely on something else which he clearly did not rely on.
But that's what judges rely on all the time when determining guilt. I mean, they determine whether the facts alleged and proven equal the mens rea that is required, right? Like, to determine recklessness, that if this had gone to trial and these facts had been presented, the judge would have to determine if this amounted to recklessness.
Well, and I agree with you there, but you just said if it had gone to trial. So if it had gone to trial, there would be facts presented, right?
But there were facts presented here in a no contest plea that the judge had to determine whether she was guilty.
But the facts actually were not presented. What was presented was the statement of facts by the prosecutor. Because
That she agreed to, right? Didn't she agree to those facts?
to the statement of facts?
Yes. In the no contest plea.
No, actually she didn't. So when you read the transcript, the statement of facts, yes, so the court asks for the statement of facts, never goes back to Ms. Hines, and then finds her guilty. So no, Ms. Hines doesn't actually agree to the statement of facts. I know there's going to be another one.
Yes, there will.
Yeah, so Ms. Hines does not actually agree to the statement of facts. I thought you were saying...
Let me ask you that. Did she tell the judges, I don't agree with that statement of facts?
So we're getting into another issue. No, so Ms. Hines, the way the transcript reads, the court asks the state for the statement of facts, and then the court immediately finds Ms. Hines guilty. So Ms. Hines doesn't say, no, I don't agree with the statement of facts. I mean, she doesn't say, no, there's no mens rea, no, there's no recklessly in there. But she does not actually say, yes, I agree with the statement of facts. But I would agree with you that in a trial, you do have facts put into the record. In a guilty plea, you're admitting guilt all the way around. But in a no contest plea, the way the statute works is it's saying, state, you have to put on the record enough to prove guilt. You can't rely on charging facts.
Okay, so she didn't agree to the facts, but these facts were presented.
Right.
And if these same facts had been presented at a trial, couldn't a judge have found circumstantially that there was recklessness here?
If those facts, no. So you're asking if the statement of facts from the prosecutor
Had been proven at a trial.
Okay.
Could a judge have found circumstantially that there was a recklessness?
That she had driven around the police vehicle and she was signaled not to.
Yes.
Could the judge? No, because then I would say that's a strict liability offense. I would say that if there was no evidence at that point that the state had put on that she had done so recklessly, and you're saying, would the court then just be able to find, based on that statement, that she had done so recklessly? I'm just saying, if the court did that, they'd be finding that it was a strict liability.
She had been told, she had been signaled not to do it, and then she did it anyway. If that was proven, would that amount to recklessness?
If she was signaled not to do it and she did it anyway.
She was signaled not to go in that direction, and she failed to comply with the order or direction of a police officer by going around the cruiser when the road was closed. If those facts have been proven at a trial, could a judge find circumstantially that that amounted to recklessness?
I would say with her statement on record at a trial, I would say no. Because if you're going to say at a trial, then I would include her statement too.
I'm not including her statement. I'm just saying based upon these facts that are in the record, could that amount to recklessness?
That she drove around a police cruiser when she had been signaled not to go in that direction. No. I think I would still say no. I think because, and the reason I say no is because that is failure to comply.
So you're still saying it's strict liability?
Yes, I
Okay.
would say that would be strict liability. Thank you.
Okay.
You have 4 minutes remaining. Mr. Donovan?
Good morning, Your Honors. For the record, Sean Donovan on behalf of the state. As an initial matter, counsel referenced at the time of the incident that there was an indication that there's a hearing difficulty in just following the car in front. That's nowhere in the record here. That is not part of the record. Whether that happened or not has not been established. It's not appropriate before this court. As far as the legal standard here, because no objection was made as to the sufficiency of the record below, we're viewing this on a plain error standard, and the Ohio Supreme Court has been clear. Is there another one?
I think that's it.
Okay. The Ohio Supreme Court is clear that the explanation of circumstances required for no contest with a misdemeanor offense is a procedural matter and does not rise to the level of a sufficiency of the evidence of an evidentiary basis or hurdle for the state to overcome like it would in Rule 29. They don't specifically state how much lower of a standard, but that it is a procedural matter and not strictly the same as Rule 29. As we know, in the Rule 29 motion challenging the sufficiency of the evidence, it is viewed in the light most favorable to the state. In the light most favorable to the state, the facts that were admitted, and they were admitted, after the recitation of the facts, counsel was asked if there was anything further, and said, no, Your Honor, that's the facts that we're admitting to today. So counsel, on behalf of Ms. Hines, admitted to those facts and admitted that she was signaled not to go around, and that subsequent to that did go around past the close. What we would argue is that that establishes knowingly. She's admitting she was signaled and went anyway. Knowingly is a much higher standard than reckless. There doesn't need to be that she was driving recklessly or that there was any reckless action. Since we've established, and the facts establish, and she admits that she knew she was signaled not to go around and then subsequently did go around, that was sufficient to establish the mens rea in here.
Is that the key that brings it out of a strict liability crime, is the fact that she was signaled and knew she was signaled?
Yes, ma'am.
Okay.
And I would, to follow up on the line of inquiry that you had in terms of circumstantial evidence, absolutely. The courts rely on circumstantial evidence all the time. And in 99.99% of all trials, there will never be the term mens rea being asked about during it. These facts, the facts that were admitted, establish not only recklessness, but establish knowingly a significantly higher standard, which the courts have said, naturally incorporates a reckless act. And if you prove the higher standard, then you have by default proven the lesser one as well. And so that's what we have here in this case. Additionally, there's talk about that post the guilty finding, Ms. Hines made a self-serving statement as, I didn't do it intentionally, I didn't mean to do this, and I was surprised when I got it. The courts are clear that the statute does not obligate the trial court to take into consideration such a self-serving statement. Any statement by the defendant at the no contest plea is not obligated. It is then sufficiency of the evidence because it wasn't argued below. Then on top of that, the plain error standards. Under a plain error standard, the sufficiency of the evidence in the light most favorable to the state, the court did not have to believe that self-serving testimony when she admitted that she had been given the signal and then subsequently did not adhere to that signal. I think I've covered most of what I wanted to. If there are no questions from the court. Thank you.
Thank you. Ms. Harris?
Just a few issues to address. The tape, there was a videotape which I believe was included in the record, and that's where the statements that when she was stopped, she did explain that she had hearing difficulty. So it's my understanding that the videotape of the stop is part of the record that should have been provided to the Court of Appeals as part of the record.
So that was played for the judge?
It was not played for the judge, but it should be part of it.
Okay.
Could we consider that? I mean, if the trial court didn't consider or didn't view that video, should we?
So that is the question, because the state is arguing that the trial court should consider the ticket, which was not part of what the trial court considered, and it's saying, well, but in finding Ms. Hines guilty, the statement that she almost caused this accident is on the ticket, but there's no evidence that the trial court considered that.
Okay.
So
I'm actually going to focus you in on a different topic. Your opposing counsel says that the explanation of circumstances establishes knowingly, which is obviously a higher standard than recklessly. How do you respond to that?
I would say the explanation of circumstances does not establish knowingly. So the state said that she failed to comply with the order of the police officer by going around the marked car after having been signaled not to go in that direction. But that doesn't establish that she did that knowingly.
Well, what if the police officer, you said she's got a hearing issue, what if the officer's going like this, and she goes around, is that knowingly then? It says signal, so I don't know what that means, whether, or he goes like this, or he jumps in front of the car and she goes around, it says signaled in the records. In my mind, it's up to the judge to determine what that means.
And we don't know if that was an audible signal, we don't know if that was a visual signal, we don't know what it was, but yes, so the state said she went around after, being signaled not to go. But I don't know that establishes knowingly or recklessly or purposefully.
Well, I mean, the issue here is whether she failed to comply with the police officer's order, right? I mean, there's no allegation that she risked serious harm. It's whether or not she complied with the order. And in this case, she was signaled and she admitted to that.
I disagree there. You just said the issue is whether or not she complied, but if you stop there, you're making it a strict liability offense, which it is not.
But okay. If there is a situation where, let's say that somebody did not plead no contest, or let's just change the explanation here, and let's just take out she had been signaled not to go in that direction. Let's take that out. Would that be different?
that she failed to comply with the order by going around the mark. Would that be different?
Yeah, I mean, if the explanation of circumstances had ended after it says around, going around a marked police cruiser when the road was closed, period. If it had stopped there, then that to me would say strict liability, but doesn't the rest of that change it?
I think the rest of that repeats it because failing to comply with the order, right, there's an order. The order is the signal. It just repeats itself. If you say she failed to comply with the order or direction, that's the same as saying she had been signaled, right? There was a signal that she failed to comply with. It doesn't, that last clause, right, she had been signaled not to go in the direction, that doesn't add anything. Because by saying she had been signaled not to go in the direction, it's the same thing as saying she failed to comply with an order.
Okay, Ms. Harris, your time has expired if you'd like to wrap up.
Thank you. Your Honor, I just wanted to, the state mentioned mens rea. You always have a mens rea in every trial. He said in 95% of the should you never mention it. Yes, you do. Always. In a jury instruction, in every trial, you always mention mens rea, unless it is a strict liability offense. Failure to comply is not a strict liability offense. The state failed to sufficiently prove its case because it did not put forth sufficient evidence on the mens rea.
Okay, thank you. All right, your case has now been submitted and we will issue a timely decision. Thank you both for arguing.